Open the meeting. This is the public hearings for code enforcement violations. I'm going to go ahead and dispense with typical opening. And swear in the witnesses. Swear or affirm that the testimony you present will be the truth, the whole truth, and nothing but the truth.
Again, good afternoon. Officer Hutchins presenting the case. 3404 South Hopkins. Mr. Martucci was found in compliance on 4/6 of 2021. Case has been closed.
Okay, what would you like do on that one in terms of cost recovery? Want to go ahead and have that cost imposed?
I'm thinking yes. Cost imposed, ma'am.
All right. And I did at the last hearing.
Yes.
And no fine to be imposed, correct? All right. So we'll go ahead and do an order. I'll do an order finding that the property owner came into compliance with my previous order. I will impose the costs in the amount of $104.39, and case is closed.
Perfect. Thank you.
Next case on the agenda is a Massey hearing 21-12. That's all right.
Good afternoon. First thing I would like to do is submit for evidence the affidavit, the notice of the Massey hearing.
Yeah, I'll accept into evidence the affidavit and the notice of hearing showing that of today's hearing.
So again, case 21-12, the respondents were Perry Williams, Erlene Williams, and S.E. Evans Jr. S.E. Evans Jr. was in attendance at the initial hearing. The violation address is 1200 Pine Valley Lane, and that is also the mailing address. The violation was section 6-56, construction permit required. So the original case was heard at the April 12th, 2021 special magistrate hearing. It was ordered that the respondent, S.E. Evans Jr., to correct the violation on or before May 7th, 2021. And if the violation was not corrected by the state, a subsequent hearing would be held and a fine imposed in the amount of $250 per day, starting May 8th. The special magistrate also imposed the administrative costs in the amount of $245.27. So a permit application was submitted to the building department on April 6th and was under review. As of today, right before the meeting, it was rejected due to insufficient information provided to it. But this time, we still do not have a permit issued.
That was the
this was where we had zoning as well as,
And the I know that there were a few violations, and and then the ultimate violation permit required.
yes, ma'am. So the items that were needing the permit were storage buildings reconstructed after the original violations were demolished, plumbing work done inside the house, as well as electrical work done on the property. Correct.
If I may add a couple of details to this case.
And today's the 10th. It's supposed to be done by May 7th. They made their application on May 6th.
Yes.
Day,
day.
May 10th. Not.
They were not
approved.
issued a permit. No, ma'am.
When did the city convey the applicant that the information provided?
I do know that on the 6th, it was noted by email back to the applicant that a survey was required.
Okay.
And today there were additional items noted for, or being looked at that are lacking. So I do know, as far as notification to the applicant, there was one email on the 6th requesting the survey.
And do you know did the applicant respond to the request for a survey?
There was no note showing any response, but Ms. Kelsey?
I have a couple of things that I'd like to add regarding this case. Just for background, this was also relating to case number 20-08, and the initial findings vacated that prior judgment. And I would like to ask that the final order today also repeat that statement that was included in the initial findings, because today's final order is the one that will get recorded. And so if that statement that was in the previous version would also be repeated, and perhaps in the title saying vacating the prior order, that would be helpful to me. In my review of the permit application that was submitted to the city, there are 3 components that need to be inspected by the building department. And with an application submitted on Thursday, May 6th, the day before the deadline, it's not feasible, reasonable, or expected that a inspection have been done within that time frame. I don't think that's the city's fault. I believe that's the applicant's fault for waiting until the day before the deadline to submit that permit application. If you would remember the presentation from last month, there was a tankless hot water heater, there was an outside sub outlet, so there was electrical, plumbing, as well as the physical alteration to the property, which was all combined in this permit application. I do think additional time is necessary, but that doesn't require a delay for the case. I think that whatever order is issued today will require that permit to be obtained, which is the one violation that you're hearing today, 656. And for however long property owner takes to complete that permit application will be time frame for the fine running. It would be my understanding and expectation from this code matter.
Well, I think an expectation for applying for a permit is properly applying for a permit. You're properly applying for a permit. My expectation would be to provide all the information to evaluate the permit. And if the city has communicated with the applicant that the information is incomplete, then in my mind, that's not a proper application. I'm going to go finding that they are not incomplete. Still outstanding information to make the permit application complete, then that's not haven't come 6-56. So finding of noncompliance. Imposing the fine that was previously imposed. $250 per day, which shall continue to run from May 8th until the violation is corrected. The cost of prosecution in the amount of $245.27 was imposed and will be imposed again in the order. I will repeat the vacation of the previous order that was requested by the city. Back in my notes, I'll repeat that and I'll add that to the title of the order imposing the fine. And anything else on that one? Great. All right. Next case on the agenda is 21-13 Brent Whitehouse.
So I am going to again start with submitting for evidence the affidavit for the notice of hearing for the Massey hearing that was mailed and posted on the property.
Accept that into evidence as Exhibit 1.
All right, so again, case number 21-13, our respondent was Brent K. Whitehouse. The violation address was 4230 Osceola Road, which is also the mailing address for the respondent. The violations were the Property Maintenance Code, Section 6-109, subsection 302.4, that's weeds overgrowth. 6-109, subsection 302.7, accessory structure was a fence. And then 6-109, subsection 304.1, the general exterior maintenance, roof, soffit, etc. So the case was originally heard at the April 12th special magistrate hearing. The respondent, who was not present at the hearing, was ordered to correct the violations on or before May 7th, 2021. The violations are not corrected by the state. A subsequent hearing will be held and the fines imposed in the amount of $25 per day for each violation starting May 8th, 2021. Also, it was imposed administrative costs in the amount of $192.44. Thank you. So this is a photo of the posting of the Massey hearing done on April 22nd, 2021. Next. Not working. There we go. So this was a photo taken this morning of the property. So no mowing has been done on the property. The fence remains. We still have portions of the fence down and new sections are falling out. And grass and weeds in the backyard, well over 12 inches in height. The blue tarp is still on the roof. No permit's been issued for repairs. So there has been no work done, no contact from owner concerning the property.
No contact. Did you ever have contact with them?
No, ma'am.
All right, I'll go ahead and make a finding that the owner did not comply with the previous order and impose the fine beginning to run on May 8th, an amount of $25 per violation for the 3 violations, and costs imposed in the amount of $192.44. Also on this case.
No, ma'am. Thank you.
That's all right. Anything else from the city?
Yes, ma'am. We thank you for that. Next month, there are no scheduled cases, so our next meeting would be in July. And the only other thing is we have some housekeeping issues that Attorney Farrell will be addressing next, and unless you have something for us, that's all I have under my.
I don't have anything.
Thank you, ma'am.
The city has gone through some recent cases to ensure that all the Massey hearing notices were provided. And after careful review of all of the cases and notes and documents, there are 3 where the city now finds that a order vacating prior orders would be the most appropriate course of action. In one of the 3, there have been additional cases. I will present first that one, which is the property located at 2280 Beechwood Court. I have with me today 3 orders from 3 different cases. Case number 20-09 is the one that I wish to vacate. I will give you a copy of this in a moment. And the 2 subsequent cases, 20-37 and 20-49, stand and remain valid liens on that property. And the city identified this issue previously and went forward with those other cases. You'll see that from the second and third pages, but that first page, 20-09, is the one that the city wishes to have vacated. And that is for you. The second case is for case number 20-23. Subject property was 406 South Park Avenue. And for this one, we had recorded the initial findings of fact document and the case is in compliance. And I believe that since no notice was provided regarding the Massey hearing for this particular case, that it would be appropriate to vacate this order. And again, I have a copy for you of the recorded page that we wish to have vacated. And then the last one is one that I would like to confer with you, Special Magistrate, regarding your opinion of whether or not the city needs to vacate this order. We have, this last one is case number 19-08 for the property located at 2975 Beale Street. We have an order finding compliance and imposing costs that was recorded. And the reason for my question to you today is whether or not the initial findings of fact order document was sufficient to provide notice. And you'll see what I've highlighted on the back of the second page.
So on 19-08, looks like the first order, findings of fact, conclusions of law, the finding of the board, you've highlighted respondents were given notice of the hearing and did appear at the first hearing. And they did appear. And that the board reserved an award of costs at that hearing. And then you've handed me the subsequent order from the Massey hearing where the board found that they had come into compliance, but they went ahead and they imposed the costs. And the order states that they were given notice of the hearing and did not appear, but you're suggesting that they did not get notice?
They did not get an additional notice beyond that findings of fact document that would have said that there will be another hearing. That was the only notice they received.
I don't think that's sufficient. No.
I didn't think so. So that would be the third and final that I would request in order of vacating the imposition of costs. And since it was recorded, we need to have an order to record to vacate it. Furthermore, I would just like to put on the record that the city is going forward with the lien amnesty program. I have had individuals contact me in response to letters that we have mailed out to properties that have code enforcement liens on them. And so far, it's been successful. I hope for a greater volume of calls as this week continues. We just mailed them out last week. And so I will keep you updated. If you have any questions about that, please feel free to ask.
Okay. So I'll summarize what we just talked about. So 1908, case number 1908, City of Titusville versus Rachel Pouncey and Justin Sheffield. The 2975 Beale Street. That is, I think that is appropriate to vacate the order finding complaints and imposing costs because there were costs imposed against the property owners at a hearing where they did not get notice of the hearing. I think it's appropriate to vacate that order. And then I'll go ahead and prepare that and you'll send that out to the owners then. On case number 20-23, City of Titusville versus Philip Watson, 406 Park Avenue, that's just findings of fact, conclusions of law. That's not an order imposing fine and lien.
I believe that document imposed costs. And it was recorded.
Well, if they didn't, did they come into compliance?
It was in compliance, yes.
Can you impose the costs if they come into compliance? Let me double check. Well, okay, so 162.07 says, if the local governing body prevails in prosecuting a case before the enforcement board, it shall be entitled to recover all costs incurred in prosecuting the case before the board, and such costs authorized. Prevailed if they clients.
Say, regarding the cost.
Respondent is assessed and shall pay the city's cost of prosecution in the amount of 163. Assessed and shall pay. But you don't record these. Record the initial.
Typically, we don't, but for this particular case, I can't explain why
Oh,
this
you
one
did
was.
record it. Okay, you did record it. All right, I'll vacate it.
Thank you.
And then third, City of Titusville versus Lorraine Silvers, case 20-09. This is the order imposing fine and lien. And I will go ahead and enter an order vacating, order imposing fine, and just 20-09. Okay. Then we're all caught up with the Massey hearing notice. Good. Anything else?
That concludes my report. Thank you very much.
Thank you, everyone. See you in